Dimitris, now the office perspective, please. Thank you.
Good afternoon, ladies and gentlemen. I hope you can hear me. I would like to thank ECTA for the invitation to participate in this distinguished panel and for giving me the opportunity to present to you the perspective of the office on the developments that followed the enactment of the new legal framework almost 20 months ago. In particular, as regards what we still call, for the sake of convenience or for lack of a better term, new types of trademarks. As we all know, the new rules entered into force on the 1st of October of 2017, and the legislator went about the abolishment of the need for the sign to be represented graphically in two stages. First, we had the corresponding requirement removed from the definition of what may constitute an EU trademark from Article 4 of the new regulation, and secondly, a comprehensive set of rules concerning the representation of the sign were added to Article 3 of the implementing regulation with a view to providing guidance on what could or could not be accepted under the new system. We've seen those provisions already many times, but every time we have a look, it is good to bear in mind that it is not just that the graphical representation requirement was abolished from the definition of the trademark, but actually that it was replaced by an open clause requiring that the subject matter of the registration be represented in a clear and precise manner. On the one hand, that introduces considerable flexibility in the system as it allows it to adapt to new technological developments, but this flexibility is delimited by the need always to comply with the principle of clarity and precision. And that requirement is set quite high because in the implementing regulation, we see that the threshold of clarity and precision is met only if the representation is, apart from clear and precise, self-contained, easily accessible, intelligible, durable, and objective. Now, you've seen, I'm sorry. There seems to be one slide missing, or rather, the order is different. Thank you. So, you've seen charts like this many times with the new types of trademarks, as Anastasia correctly said. Article 3 of the implementing regulation contains definitions for 10 of the most common trademark types, let's say it like that, by adding to the 5 types that were expressly regulated in the old implementing regulation another 5, which is position, pattern, motion, multimedia, and hologram marks. And again, as Anastasia said, in truth, only one of these new types, namely multimedia marks, is genuinely new. Position, pattern, and hologram marks were already accepted under the previous regime as figurative marks, whereas sound and motion marks were acceptable if filed as a musical notation and as a sequence of still images, respectively. However, what is important here is that 4 of these types of mark, namely sound, motion, multimedia, and holograms, can now be filed in an easier and more accurate manner by using electronic means. It is on these 4 categories and the issues that arise during their examination for absolute grounds that I will now focus. Ladies and gentlemen, this is how the legislator has set the scene for welcoming new types of trademarks into the family of European Union trademarks. But what happened after that? What happened when the new system was kicked off? Here we have the big picture of filing trends. You see that the slice of new types of trademarks, and here I count all the new types of trademarks, or what we also call sometimes unconventional or non-traditional trademarks, is a slice that nobody would like to get at the birthday party of the cake. So it's a very, very, very thin slice. We have from 1st of October 2017, 263,759 trademarks filed, out of which only 1,313 are new types. And you see that even within that category, shape marks dominate with almost 900. And then we have position and pattern with respectable numbers. And then in the trademarks, which I mentioned before, which I will focus my presentation on, we have around 50, 60 or less. So Let me then start with sound marks. In total, around 60 applications for sounds have been received, out of which 21 have already been registered and 5 have been refused. Leaving aside the pending cases, this would give a 1 out of 4 rejection rate, which, although considerably higher than average, cannot be considered as discouraging for presenting sound applications. I will first present those 5 sounds that were rejected by the office, and then I will give some examples of accepted sounds to mark the contrast. So until now, the examination shows that sounds that are neither a word or a melody, but must be reasonable, intelligible, and memorable to be considered distinctive. Here, the length of the sign and the intrinsic qualities of the sound are of particular importance for the assessment. The first sound goes on, and was considered by the examiner too long and complex to function as a badge of origin. Long and complex, although I saw Sozos dancing to the rhythm, so, well, perhaps that's subjective. And what's that? That's the second example. I don't know if it goes uphill or downhill, but that's a sound mark filed by Piaggio that was also rejected by the examiner. It was found to correspond to the sound produced by the goods themselves, in the words of the examiner, as a barge engine noise, not even sound. So we can see that the examiner had, let's say, not a positive reaction to this. What is interesting here, both marks were rejected for lack of distinctiveness, but where the sound merely corresponds to the sound of the goods themselves, there is always the danger of Article 7.1e also being invoked, either because the sound may follow from the nature of the goods or because it may be seen as performing a technical function. But this was not the case in the 2 examples I gave you. But when you see in the rejection expressions like well, that it corresponds to the sound of the goods, we can see the possibility of another ground possibly being invoked there. Now, we have another class of example here. I mean, it would be very distinctive about motorbikes, but it's about drinks. And it's about drinks. And it was rejected. The examiner just said that, well, that's the sound that one hears when opening a can of effervescent drinks, which will also be called into mind when the mark is used for non-carbonated drinks. So it didn't make the distinction between the one and the other and rejected it for the whole class of goods that it had been applied for. The next case is an example of a sound that was rejected on the grounds of being too abstract and commonplace to function as a trademark. The examiner pointed out that there was no real melody that can be remembered and that there is nothing in the sound to be perceived as a trademark, just a kind of pulsation. So again, the mark was not accepted. For the record, it had been filed with, in a range of classes for wind, solar, and water power equipment. You can see all that on the screen. Since we are pressed of time, you will excuse me if I do not read all the goods and services for which the various trademarks have been filed. And a similar case we have in the next slide. Netflix filed this sound. Well, again, here the examiner considered that if you have not heard it before, of course, the sign was not acceptable because it was not memorable and too short. He even took, or she took, the trouble to say that it was 3.734 seconds long. So we have short sounds and we have long sounds, and we see that examiners have a problem with both. Now, what has been accepted? Where is the middle ground, and what can we see to complete the picture. Firstly, it's much easier for the mark to be accepted where the sound consists of the distinctive word, which moreover is already used as a trademark, like this example.
Barça.
Right. Secondly, why are you laughing? You think it should not be registered? Okay. Yes, there is a debate going on if sounds of words spoken are sound marks. I think they are. Nothing wrong with that. Secondly, we have sounds that do not consist of real melodies, but still are original enough to be considered memorable, like the example that follows, which, as I'm told, is quite famous in Italy. Well, I already heard now. Wasn't that too long? So mark the contrast with the first example, the example where Soso's word was dancing. We can see that in one case, the mark was considered too long and complex, although it's fair to say that it was not much longer or more complex than this one. Yes, the middle ground is difficult to assess. We may have inconsistencies like this or personal views. We'll see what would happen with that. Finally, the office has also registered sounds that are quite short and simple without raising the objection of brevity, especially where the sounds show no connection with the goods or their function. So why is this registrable and the Netflix one was not? Perhaps one of the reasons that was added into the Netflix example was that it will just be seen as the beginning, marking the beginning or the end of a TV program, whereas here the goods and services were just furniture, so I don't know if that made a difference. I repeat, is all this consistent? Well, the sample is too small to draw even preliminary conclusions, but at the office we are certainly monitoring how the practice unfolds on a daily basis. Let me turn now to motion marks. We all know what motion marks are. It was explained that only moving image without sound. In total, around 60 applications have been received, out of which 24 have already been registered, while another 13 have been refused. It's worth noting that the refusal rate here is higher than in the case of sounds, again with all the caveats resulting from the low sample. I will again start with examples of refusals and then move on to examples of acceptances. And here we can see that sorry, this is a slide actually of marks that have been accepted, and again, it is the existence of word elements in the motion marks that remove any doubt as to their registrability. So here you can see that it is the same as a figurative mark you would have filed. It is just that it is moving, and of course, no question about distinctiveness. And then we have the series of examples already shown by Anastasia. Here, again, it is not so much the gesture itself, and when it comes to gesture marks, there was a big discussion whether it should be included in the new regulation as a separate category of marks. Finally, this was not the case. Anyway, they can be filed as motion marks, so it is just a doctrinal, so to speak, distinction. But again, if the movement that they show, gestures or not, is too closely related to the goods, one way or another, then this will not be accepted as a trademark, plus the danger again to have Article 7.1e invoked. So here the grounds of rejection focus mostly on this is instructions for operating or activating the goods, sensor technology, etc., which goes a little bit in the problematic of what Grégoire Bisson mentioned in the previous section. Again, here, what we have is a sign that was rejected on similar grounds. Yes. For more sophisticated kinds of electronic devices this time. It was about augmented reality and virtual reality glasses, whereas we have also examples of static images that again have to do with the functioning of the goods. This one was rejected because it corresponded to pictorial instructions of how to unpackage the goods. And then another very interesting set of examples. It's two signs filed as video file and still images, respectively, in respect of banking services, and the examiner used identical arguments in both refusals. It refused them because it found, again, a connection with the goods in the sense that these examples, now you can see the video up on the left, and also the series of still images would just be perceived as an activated chart, so it's nothing particularly memorable in the financial sector about this. So not an indication of origin, the examiner said, but rather a functional or a feature of the services. It remains, however, unclear whether the examiner's statement that, because the examiner also said that in general motion marks will not be perceived in the same way as word or figurative marks. So is that statement, which is not further explained, sufficient to justify the fact that in substance the same mark was accepted when filed as a figurative mark? You can see it down in full deployment. Actually, the figurative mark is the last carré of the video shown up there. Food for thought. Now, a very interesting contrast again comes from the same consideration that Nastasia said, that we have gesture marks that have been accepted when they are not connected with the goods and services. So in this particular case, you can see the goods. It is a sign for promoting awareness about the activities of a charitable foundation. So in relation with the goods and services, Article 1b must always be assessed in relation to the goods and services. That was found to show no problem at all. So what we see already emerging is that the link with the goods sometimes is more important than the originality of the movement. The next example is also very, very interesting from a theoretical point of view, because when we have when the motion is applied to words that in certain circumstances the movement could be seen as adding to the distinctiveness of the elements that move, is a real question. So this trademark, the expression win-win, might not have been registrable. The truth is that the movement here has some originality in the way it goes up and down. So was that the crucial factor? And we have also, as you can see, perhaps one could think both ways, that, well, it's just the words win-win that move, and therefore it's not distinctive. Or you can think that, yes, it's the expression win-win that moves in a way that, that is original and will be remembered, and for that reason the mark is registrable. Similarly, we have examples of this is a whirling movement in a bottle. It was accepted for beverages, and this time it has a possible connection with the goods. So why was the objection not raised here? And what is also interesting is the next example, the next acceptance of a heartbeat for foodstuffs. I guess it is about healthy foodstuffs. And to mark the contrast with another heart device that was actually rejected, which one could say is even more fanciful, that was rejected as a figurative mark by the General Court. So is it again the movement of the heart that made the difference, or was it the fact that in the second example we have to do about medical apparatus, and in the first case about foodstuffs? So in the first case, in the rejected case, let's say that the link with the goods was much more direct. Still, again, food for thought. I will move on now to multimedia marks. By definition, multimedia marks are trademarks consisting of the combination of image and sound. Only 25 such marks have been filed, and they show by far the highest acceptance rate among new types. So you may have situations where, as you know, these examples from previous presentations, again, the movement and the sound are combined with aired elements. So here, in both situations, there is no question about the overall distinctiveness of the sign. Or you may have then more examples like these ones. That's an interesting one. the movement, a movement that is not obviously connected with the functioning of the goods, or there you can have jingles that are, let's say, funny or low originality, and these cases have been acceptable. I also have the two examples shown by Nastasia earlier. I think the rejection grounds here are sort of obvious. Nobody would remember this as anything else than just a message saying that the sale is ongoing. Hologram marks, we have 3 filed, actually. There was a 3rd one filed very recently. Again, as it was said before, they are a category in themselves, and what is very interesting in both cases here, we had word elements embedded in the hologram marks. Again, the first one, the combined effect, the distinctiveness cannot be denied, especially in view of the word. However, the question here is, if you didn't have the words in the first example, whether just showing the external appearance and the hologram effect on the external appearance of the goods is enough. Another interesting category, other, it's important that this is not reserved exclusively for exotic or exceptional types of marks. It can provide prove particularly useful in cases where the applicant wants to add a comment about a special feature of the sign. Here you can also file a description, which is not the case with all other marks. So if you want to file a figurative or a shape mark with a special twist, for instance, just add a suitable description and file it as other. I want to show you also one example about other marks. This is what, again, is often called in our guidelines even as tracer marks, which are very much in fashion, for instance, in the textile industry or hoses or cables. This has been accepted for elevator ropes. So the question is, why did we accept something that was filed as other in a situation where we most likely would have objected to if it was filed as a shape mark because it shows the external appearance of the goods? The answer is simple. It is because the court has said that the reason why we don't register shapes or colors applied on shapes is because they are usually seen as ornamental features of the goods. And here, obviously, the mark does not have an ornamental function. I mean, who wants to decorate elevator ropes? So that's the ground for the acceptance. I will just show you 2 examples of oppositions that have already been filed against new types of trademarks. Here you have the first one. As you can see, when it's fully deployed, it gives one of the words that has already been registered, and the same applies for this example. Very early stage, I'm sure we'll have an opportunity to discuss again about them. And just a couple of words about CP11, which is the project that it is ongoing. I hope it has become clear from my presentation up to now that the practice developed slower than predicted in view of the low number of trademarks filed, and that in the member states we have even lower numbers. So that's why we created this convergence initiative, CP11, that you already know about, which, for lack of real cases, is largely constructed on the basis of imaginary examples in a laboratory setting. So here, yes, we have the work already initiated. There are 3 working groups that have already taken place about CP11 for the absolute ground stream, and for the relative ground stream already some discussions have started. You can see some of the examples used. So the flying sardine here over the water is an example of a distinctive multimedia mark for sardines, since the sardine is not swimming but flying, and so on and so forth. I will just leave it here because we are very short of time. Thank you, Vats, for your attention, and I hope that we have more conclusions to draw next time we speak about new types of trademarks. Thank you.
Thank you, Dimitris. It was speed of light. Thank you for that as well, and for the very interesting presentation.